I was on the BiggerPockets forum and noticed a Georgia investor trying to figure out how to protect her Georgia rental property and her California rental property, but she was confused about how to set things up. Specifically, she said, "I am trying to set up an anonymous holding LLC and one anonymous Georgia subsidiary LLC for my Georgia rental, and one anonymous California subsidiary LLC for my California rental. I'm a bit confused about how to set it up. Could you share your view on this?" She then went on to talk more specifically about the dynamics of that setup by asking, "Should I set it up as member managed? Should I put my holding LLC as the member?" I read all the responses to Gina, the investor, and I actually felt bad for her because many people were criticizing her, wanting to know why she cared about asset protection and protecting only 2 rental properties. In fact, some people were even asking her if she was just a celebrity and why any of this stuff mattered, because people really don't need privacy. So I thought I would put this video together to answer Gina's questions and help anyone else who may be wanting to know how to protect rental properties in different states, even when those state laws may be different for asset protection. I'll explain what this specific investor should do for her situation, and then I'll give some tips and tricks later about how to manage these LLCs and make sure that you have asset protection. Let's answer Gina's first question. If she currently has 2 rental properties and she wants an asset protection plan that both provides her protection from a greedy lawyer getting to her personal assets and that same greedy lawyer being able to get access to her Georgia property and her California property, what type of holding company should she set up and what state should she set it up in? Gina was right to consider a holding company to protect rental properties when she is a multi-state investor. This is especially true if you own rental properties in states with weak LLC laws. First, let's define what a holding company is. A holding company is an entity set up for the express purpose of holding other LLCs in states set up where the rental property is located. Basically, holding companies are a strategy that you can use to borrow another state's beneficial laws when the state that your property is located in has weak LLC laws. But in order for this strategy to work, you have to know which states are best to set up a holding company and which states are weak that you shouldn't even consider. For example, Georgia and California do not provide you the combination of privacy and charging order protection that you would need in order to make sure that you are protected from your personal assets being reached or your rental properties being reached in the event of a lawsuit. Let's stop for a minute and focus on something that's really important. Many of the commenters on that BiggerPockets forum were giving Gina a really hard time, saying that asset protection really didn't matter and that LLCs don't really protect your rental properties anyway. Here is the reality. Rental properties are one of the highest risk assets that you can own. I'm not just talking about within real estate. I'm talking about in any asset class. Why? Because you have people coming in and out of your property. If it's a short-term rental, you might have thousands of people doing that. If you have an actual renter that's there, they are staying there every single day. And the reality of it is, if someone gets hurt on your property, the target is going to be you. The lawyer's coming after you, the renter's going to think you are the deep pocket, and they are going to want to sue you for damages. Why? Because under the law, every rental property owner owes each renter a duty of care to provide both a safe environment and a habitable property. This is measured under what we call the reasonable person standard. So what would the reasonable landlord or short-term rental host, what would they do whenever they're renting out a property to a renter or a guest? If someone gets hurt on your rental property, you can absolutely guarantee that they are going to hire a personal injury lawyer and they are going to come after you as the deep pocket because you own the property. They will file a premises liability lawsuit against you. Under the law, if an attacking attorney can prove that you breached your duty of care to that renter or guest, they can get a judgment against you and they may be able to force you to sell your property and get access to your personal assets because you lost the lawsuit and now you owe money damages. This can be really bad too. The reason why is because that attacking attorney, once they get a judgment against you and you don't have asset protection, they could actually make you sell everything you own that is not protected under the bankruptcy code or the state homestead laws. and you could end up being in a very dire financial situation. Let me give you an example of what I mean. I actually had an investor reach out to me where they had gone into a lawsuit situation where it was a simple matter. They didn't do anything wrong, but they had a guest come and stay around Thanksgiving. And during that period of time, right before the guest showed up, they actually had septic maintenance to come out and check everything. They were trying to be good property owners. Problem is, the septic maintenance company did not take the time to make sure and put the lid back on the septic tank. So when the guests showed up and they were having a great time, one of the 7-year-old boys who was out there playing fell into the septic tank. And not only did he escape barely with his life because he fell into a tank, but he also ended up with pink eye. He ended up with some pretty serious infections. And as a result of that, who do you think they sued? They hired a personal injury lawyer. They didn't sue the septic maintenance company. They turned around and sued the homeowner because they claimed they had the duty of care to provide a safe environment. Now I get it. The homeowner could turn around and sue the septic maintenance company, but I want you to understand, this is the importance of realizing if someone gets hurt on your property, the lawsuit's coming against you. With all that said, what state should Gina set up her holding company in? Gina should seriously look to state laws that provide a combination of both privacy and charging order protection. Attacking attorneys will immediately begin to do asset searches on anyone that they can tell who is in control or owns the property. Here's the way it works. An attacking lawyer will go to the Secretary of State looking to see who is on the LLC. If they are able to tell who is actually running and managing the property, they will turn around and do asset searches to find out what other assets they own, what profession they're in. But if they are confused about who is either in control of the property or who owns the property, it makes it more difficult for them to profile you. But what about charging order protection? Why does that matter? And what is it? Well, here's the deal. Unfortunately for Gina, if she were to get into a lawsuit where her Georgia rental property and a Georgia LLC or the California rental property and the California LLC were to be sued and she lost, here's what could happen. The greedy lawyer could force her to sell that property in order to satisfy the judgment against her, which means now she's actually lost this investment that she spent all of her hard-earned time and money on in order to create some cash flow for her family. But if she sets up a holding company in a state with charging order protection, that greedy lawyer cannot make her sell the property even if she loses the lawsuit. Think about that for a minute. Most personal injury lawyers are going to get paid on what's called a contingency fee basis. That means they are going to have to pay for the entire amount of the lawsuit out of their own pocket on the front end, and they only actually get paid if they recover and they can force her to sell her property. So, how do you think an attacking attorney will see Gina if she sets up a holding company in a state where, number one, she's private and they're not able to tell that she owns or controls the asset, but number two, that attacking attorney now realizes that they cannot force her to sell the property even if they win the lawsuit. Now all of a sudden, Gina becomes a very unattractive target to an attorney. When you become an unattractive target to an attorney, here's what happens. Now that attorney starts looking down to the insurance for the easy button to resolve the case. I say this over and over again. Good asset protection pushes lawyers down to good insurance, so that way they're not coming after you. So Gina's situation teaches us all the importance that if you have a rental property in a state that has poor LLC laws, it's important that you set up a holding company in a state that has beneficial laws that can then provide you real asset protection for your properties in those respective states. One of the best states to do that in can be Wyoming or Delaware because they provide you both charging order protection and privacy. So, since Gina has 2 rental properties right now, she should consider setting up either a Wyoming LLC or a Delaware LLC as her holding company. Here's how it would work. She could set up single member LLCs for both her Georgia property and her California property. She could then move those assets into those single member LLCs. But the single member would not be her. Instead, it would be held by a Wyoming or a Delaware LLC holding company. If an attacking attorney now comes to, say, California, right? Let's say somebody has a slip and fall incident at her California property. Now they'll have to start off attacking that California LLC. When they go to the California Secretary of State, the Secretary of State will inform them, hey, it's actually a single member in Wyoming. So now that attacking attorney will have to check with the Wyoming Secretary of State, but what they will find is that there are privacy laws where the names of the members are not disclosed in that situation. And then more importantly, now the attorney will also learn that there is charging order protection where in this situation, even if Gina were to lose that lawsuit, she cannot be forced to sell the property. She can continue to rent it out. She can pay all of her expenses. She just cannot take an owner's distribution. But once again, it creates a disincentive for the lawyer because the lawyer wants to get paid. And now she has legitimate asset protection. By doing this, here's what happens in a lawsuit. If an attacking attorney now comes to sue, let's say the California property, right? Let's say there's a slip and fall at Gina's California rental property. Now they go to sue the California LLC. But when they get there, they're going to be informed that the single member is not her, but instead a Wyoming LLC. But when that attacking attorney now goes to the Wyoming Secretary of State to look into what's going on, they're going to be stopped at the front door because there's privacy laws in Wyoming. But here's what's important. Now that attacking attorney will not even know Gina is involved in any of this. Privacy? Check. The lawyer will also learn that because Gina set up her holding company in a state that provides charging order protection, that lawyer is not going to be able to make Gina sell her property even if she were to lose the lawsuit. Charging order protection? Check. Now Gina has a plan to really protect her assets. But even if she knows what to do now for protection, how should she set up her LLCs when she files them? Gina asked this second question. She said specifically, should I set it up as a member manager instead of a manager managed LLC? And then she went more specific about her primary holding company and subsidiary LLCs. She said, should I set up my holding company as the member or should it be member managed? There's a lot of different wording going on in here. So let's break this down. What is a member managed LLC and what is a manager managed LLC? As a general rule, in a member managed LLC, the owners or members are responsible for the day-to-day management. However, in a manager managed LLC, many times the owners or members may appoint a manager or hire someone to actually manage the business. Gina seems a little confused on this part, so let's simplify the setup. Gina goes on to say that her primary concern is that she wants to make sure that she has privacy and she wants to make sure the member or manager setup is accurate. So in order to achieve this, she can simplify this very easily. Georgia property in its own single member LLC. California property in its own single member LLC. Any future rental property, she can place it in its own single member LLC in the state for where the property is located. Gina can then make the single member be held by either a Wyoming or Delaware LLC holding company. By doing so, the Secretary of State in Georgia or the Secretary of State in California will direct that attacking attorney to that holding company where they will now have to go find out who the member is in Wyoming or Delaware. At this point, you have more flexibility to set up your holding company as either member managed or manager managed, depending upon your financial and business goals and needs, which further emphasizes the importance of talking to good legal counsel when you're finalizing a good asset protection strategy. The best part? Gina can buy more rental properties, place them in single member LLCs in the state for where she's buying the property, and have them held by the same holding company that will provide every one of those properties both privacy and charging order protection. Is Gina done? Not quite. Gina later mentioned that she bought 3 distressed properties and now she has doubled her real estate portfolio. Is there a strategy that is even more robust that will provide her more comprehensive asset protection now that she has more to lose? There sure is. Check out this next video where I go over our premier plan that talks about a special holding company strategy for larger real estate portfolios. See you over there.